I wanted to provide some updates on what's going to happen with the pilot program here in North Carolina. I work with NC State Extension and Hemp Law, and I'm with the Department of Agriculture and Resource Economics at NC State University. So just a quick disclaimer, because I am an attorney. In my position with Extension, I don't provide legal advice. So this presentation is for educational and informational purposes only. So the questions that I want to answer today are, when does the North Carolina pilot program expire? A lot of folks know that it's going to expire. I just want to talk about when, and I also want to talk about what's going to happen and what's going to happen to our licensing program once it does expire. So just to provide a little bit of background really briefly, it is our fourth growing season right now in North Carolina. We have approximately 1,500 licensees, so our program has grown very quickly. And so far, the majority of growers have been and currently are growing for CBD. Our pilot program was authorized under the 2014 Farm Bill, and it is still in place right now today. So our pilot program is still currently in place. If you want to grow hemp in North Carolina today, you do still need to get a license from NCDA. However, we do know at the end of October of this year, our pilot program will expire. So in order to better understand where we are with our pilot program today, I think it's important to also look at federal law, because when we're talking about hemp law, and especially for licensing programs, we're at the intersection of federal and state law, and we're also in a transition period between the 2014 Farm Bill and the 2018 Farm Bill at the federal level. And that's part of what makes this transition confusing. So just to give us a little bit of context for how we got here, the 2014 Farm Bill, which is a law that Congress passed, so it is a federal law, it gave permission or it gave authority to state departments of agriculture to create pilot programs. So again, this is where the authority for our current pilot program comes from. It also gave us a definition of industrial hemp. So if you're wondering where that 0.3% or less of Delta-9 THC on a dry weight basis, where that came from, it did come from Congress through the 2014 Farm Bill. In 2018, in December 2018, Congress passed the 2018 Farm Bill, and it loosened restrictions even more on industrial hemp. It took hemp out of the definition of marijuana in the Controlled Substances Act, which was a big deal, and it really helped to provide more freedom in terms of what people could do with hemp and how hemp was seen. It also said specifically in the Farm Bill that hemp is to be treated as any other agricultural commodity. We know that that's the intention of Congress. We do know that that hasn't been completely true. I can't think of any other commodity that you have to have a license to grow and then you have to have tested before you can harvest. So we know that there are still some restrictions on hemp that don't exist on other commodities, but at the same time, this language in the Farm Bill did help to provide more support, especially through federal programs, federal grants for hemp. So the 2018 Farm Bill created a shared federal and state regulatory authority over production of hemp. And it also specifically gave USDA AMS, or the Ag Marketing Service, authority to create and then administer a national hemp program. So under that authority, at the end of October of 2019, the USDA published what's known as their interim final rule, or IFR. Under the IFR, it gave the USDA 2 years to develop their final rule. It also said that states may submit a state plan to USDA, but it doesn't say that states have to. So states have had a choice as to whether they want to submit a state plan or not. It also provides a framework for what states will have to put in their state plan if they do decide to submit a plan to USDA. So USDA provided some guidance as to what would have to be in those state plans. So for example, there are licensing requirements. It says that there has to be a way to track land that's used for production. There has to be testing protocol for THC. So these are things that we already have in place under our pilot program. It also says that labs that perform testing have to be registered with the DA to handle controlled substances. that was originally supposed to go into effect, I believe, immediately or in 2020, but USDA has since said that specific provision won't be in place for 2020. It also talks about disposal of plants and what some of the approved ways are that plants that test hot can be disposed of. We know that there are some concerns or some issues that have come up under the USDA's IFR. The reason I wanted to talk about these today is because, again, our pilot program is expiring at the end of October right now, and I'm recording this on October 14th, 2020. So as of today, it does look likely that we will come under USDA's plan. So I just wanted to go through some of the main concerns that folks have about the USDA's IFR. So the main focus of the concern has to do with testing for THC, so that compliance testing. One of the things it says is that harvest has to be done within 15 days of testing. That is different than what we have in North Carolina. In North Carolina right now, under a pilot program, upon flowering, growers have to contact NCDA for testing. Once NCDA is contacted, then they will make arrangements with the grower to go out and conduct testing. But there's no specific time limit or time frame, and it's certainly not as restrictive as this 15-day limit. So the second issue is that anything that tests above 0.5% is considered to be negligent. It's a negligent violation under the USDA's interim final rule. And then it also says that if a grower has 3 violations in 5 years, then they are banned from the program for 5 years. So that means if you test hot 3 times, then you end up losing your license and you can't participate in USDA's program for up to 5 years. So that is a lot more stringent than what we have in place currently in North Carolina. In North Carolina, if you test hot, NCDA will provide another test. At times, they have provided 3 tests. If after that second or third test, you still test hot, your crop will be destroyed. However, there's no ramification directly to the grower's license. So in North Carolina, under our current program, if you test hot 3 times, you do not lose your license. So that is considerably more restrictive under the USDA's rule. And again, the reason I wanted to mention these issues is because it does look more and more likely that growers in North Carolina will end up applying for a license if they want to continue to grow under USDA's plan starting in November. Again, as I mentioned before, under USDA's interim final rule, states may submit a state plan to USDA, but they do not have to. If a state doesn't have an approved plan and they don't intend to submit one, then growers can apply directly to USDA for a 3-year license. At this time, I don't think that USDA is charging a fee for their licenses. I'm not sure if that will continue or not. And also right now, if you're a grower in North Carolina, you can't go to USDA to get a license directly from USDA because we do still have a valid and legal pilot program. So because our pilot program is still in place, you cannot go to USDA to apply for license. USDA said very clearly that they won't allow dual licensing. So that means that growers from, for example, the state of North Carolina, you can't have some growers who are applying to the USDA for license and some growers are applying to NCDA for license. USDA won't allow that. So at this point, it does not seem likely at all that in North Carolina, we will be able to submit a state plan to the USDA in time before our pilot program expires at the end of October. So that was a reason that the North Carolina Farm Act, or what's known as SB 315, was really important. There was language in there that would have given NCDA authority to develop and submit a state plan. There was also a provision in there about smokable hemp, and it would have potentially put a ban on smokable hemp here in North Carolina. However, that Farm Act was passed by the General Assembly in June of this year, but before it was passed, all of the language and all of the provisions that were related to hemp were stripped out. So what that meant was, again, we never had a ban on smokable hemp here in North Carolina, but it also means that NCDA currently doesn't have authority to submit a state plan to USDA. The other piece of this is that USDA has said that plans have to be submitted by mid-August in order to be approved by that end of October deadline. Again, today is August 14th, and right now NCDA doesn't have authority to submit a plan to USDA. So it seems highly unlikely that we will be able to submit a state plan in time for the end of October. So as a result, again, our pilot program will expire at the end of October of this year. When our pilot program expires, it means that all of those 1,500 licenses that were issued so far under our pilot program will also expire. So at that time, once our pilot program expires, and then growers can apply directly to USDA for a license, because again, you can't have that dual licensure that I just talked about. But once our pilot program expires, then it's going to be okay for growers to apply directly to USDA. One thing that's not clear, though, is exactly how this transition between a state licensing program and a federal licensing program is going to work. We are hoping to get more guidance from USDA. So, for example, if you are a grower and you wait until the final, or right until after our pilot program expires, and then you apply to the USDA for a license, I don't know how long it's going to take the USDA to issue your license. So we want to make sure that our growers are not going to be out of compliance for any amount of time, particularly for our indoor growers. We want to make sure there's no gap in licensing, so that the day that our pilot program expires, our goal is or our hope is that our growers will be able to have a valid USDA license that very next day. But again, we haven't had the guidance from USDA as to how this transition will occur. So there is one possible alternative to what I just talked about in terms of the pilot program expiring, and that is that Congress has the authority to tell USDA that they have permission to extend pilot programs until 2021. There is support to doing this from NASDA, the National Association of State Departments of Agriculture. There has been support from our State Department of Agriculture, and I know there are other states who would also like to see this happen, who might be in a similar position to North Carolina. There has been language that was introduced in an appropriations bill in Congress. However, it has not been passed into law yet. So I don't know how likely it is that that this language will pass. So again, there is I want to say a small possibility that Congress will pass something that allows USDA to extend the pilot programs until 2021. But again, I don't have a crystal ball. I don't know how likely that's going to be. So a quick summary of where we are today. Hemp is legal. We know that hemp is legal. It's been legal in North Carolina for 4 years now. We know that there are still some restrictions. And as I said earlier, we are in this place of transition where we are transitioning between the federal 2014 Farm Bill and 2018 Farm Bill, and also at this intersection between changes in state and federal law and regulations. So if you're a grower in North Carolina right now, you still need to follow the laws of our state. Again, we're operating under a pilot program. So if you are growing during the 2020 growing season, you do still need to have a valid license from the NCDA. If you don't already have a license and you would like to grow hemp in North Carolina, we'd say proceed cautiously. We know that the law is very unsettled. We know that there's a good chance the law is going to change at the end of October. So just proceed with caution. Understand that there are risks. And I would add finally that just like Dr. Tom Milton says at the North Carolina Industrial Hemp Commission meetings, don't invest more than you can afford to lose. We know that there is some market volatility right now. So I have listed some additional resources. You can find updates on law and on production of hemp at our Extension Hemp portal, and I have the website listed here. I've also listed the website for USDA, and you can find the interim final rule there. You can find other information about the domestic hemp production program on that website. And if you have any questions, feel free to contact me. My email address and my phone number are on this slide. We also have a group of folks on campus who work in hemp, and you can find our email address here also. And that email will go to all of us. Whoever gets it first and is able to answer your question will answer your question. So you can always contact us at industrialhemp@ncsu.edu. Thank you.